Ladies and gentlemen, good evening. Welcome to Politics in the Pub. My name is Howard Bell. I'll be chairing the session this evening. What we'll be doing is kicking off shortly, and I'll be introducing our two amazing guest speakers. Now, I was talking over dinner with some people from Green Left, and they showed me their latest newspaper. And it says this, plan for 100% renewables now. Major parties ignore climate. Now, I said to them, this is a very good edition of Green Left, but your next edition should say the same thing in relation to human rights and social justice. And down the bottom, it should say both major parties ignore human rights. So the topic tonight is a Human Rights Act for Australia. Is there one on the horizon? I don't think there is personally, but that's just my view. And I can't think of two better speakers to share their insights about that at this stage, this critical stage, in the lead up to a federal election, than Louise Goodchild and Belinda Lowe. I'll introduce them both. Louise Goodchild is a legal expert and a barrister practising at the New South Wales Bar. She practices across a broad range of legal areas and also specialises in human rights law, equal opportunity, anti-discrimination law, administrative law, as well as children's care and protection and family law. Louise is well known for her analytical and research skill and for having successfully challenged the status quo in a number of key areas. She's also, as well as being a barrister, she's been a judge. She sat on as a judicial member of what used to be the Administrative Decisions Tribunal, but now it's called the NCAT. And in the NCAT legislation, it actually authorises the pet name of NCAT. So I'll also introduce our second speaker, the amazing Belinda Lowe. Belinda is an activism, growth and development coordinator at Amnesty International Australia. She develops mass mobilisation strategy for Amnesty's Indigenous rights and also in relation to other key campaigns within Amnesty. That includes the campaign against the death penalty, torture, and individuals at risk, and the campaigns associated with individuals at risk. And she's campaigned across a range of important areas, including public health, environment, women's rights, and human rights. She also has a BA in public communication and a Master in Peace and Conflict Studies. So please join me in welcoming Louise Goodchild and Belinda Lowe.
I acknowledge the traditional owners of this land and their elders past and present. Thank you for asking me to come and talk with you again this year about why we need a Human Rights Act in this country. I was here about 12 months ago speaking on the same topic, and back then Tony Abbott was Prime Minister, and I opened my talk with the following. I really think Australians are sick of being lectured to by the United Nations. I don't know if you remember that little cracker of a number from Tony. When the UN were criticising Australia about the violation of the rights of asylum seekers and the Convention Against Torture, Tony came out with that. 2015, the leader of this country saying that Australians are sick and tired of being lectured to by the UN. Anyway, I couldn't resist trotting it out again. I want to do two things tonight. I want to talk to you about why we need a Human Rights Act, and I want to have a brief conversation with you about what I think is the singularly most important human rights issue currently facing our community. So to the Human Rights Act. Since Federation's successive Australian governments have justified the absence of a Human Rights Act on the basis of the existence of what's called or what's known as representative and responsible government. What does that mean? What that means is effectively we've got a representative government, we've got a responsible government, we don't need legislation, we don't need anything else to protect the rights of our citizens, to protect the rights and the human rights of individuals in this country. We're from the government. We're here to help. Really? Responsible, representative government protecting our rights? Northern Territory intervention, children in immigration detention, asylum seekers, offshore processing, secrecy laws, the condition in prisons, terror laws, metadata storage, gay marriage, juvenile justice, the systemic perpetration of violence on women, incarceration rates. Really? Representative and responsible government has protected our rights in this country? In 2009, after an extensive consultation across Australia, it appears that the vast majority of people, the vast majority of Australians, are in favour of a Human Rights Act. And another often trotted out message in opposition to the Human Rights Act is that we have existing state and federal legislation, we've got a Human Rights Commission, we've got courts, that's enough. The last thing we need is any more legislation, the last thing we need is any more lawyers. Australia has been described as having a patchwork quilt of protection for human rights. We have made commitments to a range of obligations under international human rights law, but these obligations are only enforceable in Australia if implemented in domestic legislation. Although there are numerous mechanisms for holding Australia accountable internationally, they are not legally binding, and their recommendations can be and often are ignored by Australian governments. We also have strong democratic institutions, but they do not always ensure that human rights, and in particular minority rights, receive sufficient consideration. In Australia, as a result of probably the 2009 consultation, the favoured model for a Human Rights Act is a Human Rights Act, a piece of legislation, as opposed to amending the Constitution. As you know, to amend the Constitution, it would have to happen by way of referendum. And once enshrined in our Constitution, it would be near impossible to update and amend. When something's in the Constitution, it's the courts that have the final say in its interpretation, and Parliament cannot overrule the decision. The only way to change the law enshrined in the Constitution is to change the Constitution or have the court change the decision. So the preferred model is for a piece of standalone federal legislation, a Human Rights Act, in the theme that has been already introduced at a state and territory level in the ACT and also in Victoria, a piece of legislation called the Charter of Human Rights and Responsibilities Act. I say there's three main reasons why we need a Human Rights Act, a federal Human Rights Act. The first is because it will make it more difficult for any government to take away our rights and to promote a culture and respect for human rights. The second reason is because it will have a significant influence on our other laws. And thirdly, it will bring Australia into line with the rest of the Western world, and it will unify our current patchwork of rights. I'll deal briefly with those three reasons in turn. We currently take for granted a number of rights that are not explicitly granted to us. Freedom of speech, is that a right enshrined in legislation? No, it's not. It's mentioned in some acts, it could probably be implied into others, but it isn't defined per se. Freedom of religion, again, not enshrined in any legislation. Certainly it would be very difficult for a government to ban most religions, but you have no right to stop the government restricting religious activities if it wants to. A lot of Australians hold dear, a lot of the rights that Australians hold dear are only rights in the sense that the government hasn't passed a law taking them away. By and large, generations of politicians have respected the powers we have entrusted to them. They have tried to act reasonably and not undermine conventions and institutions to obtain political objectives. We don't have a perfect record by any means, Aboriginal rights being one shameful example. But our culture of mutual respect and a fair go has granted Australians a degree of freedom and social stability that most countries have fought hard to obtain. And it is perhaps because of that past that we risk becoming complacent in the future. The greatest strength of our democracy can also be our greatest weakness: reliance on mutual respect and the goodwill of those in power, responsible and representative government. So unfortunately, I have identified earlier, successive governments have shown an increasing willingness to push the limits of their power regardless of the criticism they face. Again, the intervention, the children in immigration detention, etc. And it is dangerous indeed when a government becomes immune to political and international criticism. The UN unequivocally stated that Australia's current asylum policy breaches the Convention Against Torture. The government made no changes in the face of that criticism. One of the most desirable outcomes of a Human Rights Act is that it makes it harder for a government to pass a law that violates human rights. Sure, they can overrule the Human Rights Act, but that's the point. They actually have to stand up and say, we, your government, we're going to take away some of those rights. This is why, this is how. So it makes any violation of rights much clearer. It makes any violation of rights much less palatable, and perhaps more importantly, it makes any violation of rights accountable and open to debate. It won't work every time. In all liberal democracies, things work on checks and balances, and there's no silver bullet to prevent a government from overreaching. But a Human Rights Act regime provides a whole series of small measures that make it increasingly difficult for any arm of government to overstep their powers, by forcing governments and bureaucracies to actually think about the human rights implications of their actions. Over time, a culture of greater respect for those rights develops, and it's happening. There are signs that in Victoria and ACT, where they've already passed State and Territory Human Rights Act, that there is this idea of compliance with rights narrative that's emerging. Before they make or pass legislation, they have to actively consider their human rights legislation and whether or not that legislation complies with it. Many countries have allowed citizens to sue for serious breaches of the rights contained in a Human Rights Act. Let's say, to use a hypothetical example, the Australian Federal Police arrests you for days because a friend of a friend of a friend used an old SIM card of yours soon before he committed a terrorist act. Eventually, you're released without charge, only to be placed in immigration detention and deported from the country. You may think that that's a grossly disproportionate and unreasonable use of power. You'd be right. I'm talking about Dr. Mohammed Khanif. Thankfully, his case was high profile enough that the government forced to back down and apologise. But for all those cases that don't generate public attention, though, a Human Rights Act may well be the only way people get some sort of redress or get some sort of compensation. Some commentators have said, oh, well, it'll lead to a flood of mostly frivolous litigation. But other countries where a Human Rights Act has been passed, for example, the UK, it seems that the average increase in litigation is less than 2%. And let's not forget, the people suing are doing that because their human rights have been violated, and that cannot be a bad thing. The second reason why I think it's important to have a Human Rights Act is that it can be used to interpret other laws. Grey areas exist throughout the law, situations which don't quite fit with existing definitions, and you really can't be sure whether to interpret them one way or another. Currently, the courts can choose between a very narrow set of interpretations, and despite the convincing arguments of Dennis Denuto in The Castle, the vibe is not an accepted legal test. A Human Rights Act would give courts the flexibility to interpret situations in a way that delivers the best outcome in a given situation. And the third reason, Australia is unique amongst the liberal democracies in that it has no Human Rights Act. New Zealand, Canada, the UK and the United States, they've got a Human Rights Act in one form or another. Simply put, it is a source of international criticism and concern that undermines Australia's moral standing on the world stage. Instituting a Human Rights Act would not only bring Australia into line with its peers, but also unifies the rights and protections that Australians are entitled to. Currently, our rights resemble a Jackson Pollock painting. We've got some in the Constitution, we've got some in legal convention, we've got a haphazard sprinkling throughout legislation. Bringing these rights together into one act, even if it doesn't necessarily increase their force, will in and of itself inform and protect Australian people. So, will Australia fall apart if we don't have a Human Rights Act? Probably not. In all likelihood, we will remain in a fairly free and respectful society well into the future. But a Human Rights Act increases that likelihood. It increases respect for human rights and makes it more difficult for those human rights to be taken away. Everyone benefits from protecting the rights of a society as a whole. I said to you at the beginning of the talk tonight I wanted to speak about an issue that I thought is the most pressing human rights issue facing us as a community today. That issue is the incarceration of Indigenous people, particularly young Indigenous people. And I'm just going to outline the problem briefly, and I'm going to do that by rattling off statistics, which I normally hate doing, but in this case it is necessary because it is extraordinary. And as I rattle them off, I want you to think about the men and women, the children, and your own children. The proportion of Indigenous prisoners has almost doubled over the last 20 years since the Royal Commission into Aboriginal deaths in custody. Across the country in 2015, 28% of Indigenous people comprise the prison population, despite only accounting for almost 3% of our population. In the Northern Territory, the rate of Indigenous people in prison is close to 90%. In 2010, 30% of the women in prison were Indigenous. The situation is worse for young Indigenous Australians who come into contact with the justice system. Indigenous kids between the age of 10 and 14 years are 30 times more likely to be incarcerated than their non-Indigenous peers. On average, tonight, 53% of young people in custody will be Indigenous kids. The recidivism, the re-imprisonment rate for Indigenous young people is higher than their school retention rate. In the Northern Territory, between 2004 and 2014, the Indigenous population in the jails has increased by 50%. The Northern Territory rates third in the world behind China and the US for its incarceration rate. In WA, young Indigenous people, who are a very small fraction of the youth population, comprise 3/4 of the mandatory sentencing cases. in 2013 and 2014, 87% of kids between the ages of 10 to 13 in detention in Western Australia were Indigenous kids. We probably all remember the mandatory sentencing laws that came out in '96 in WA, where it was 3 strikes for those convicted of home burglaries. The last publicly available figures from 2001 show that 81% of the 10 to 17-year-olds sentenced under this law were Aboriginal kids. And young Indigenous people in remote regions suffer more than most from the lack of suitable accommodation, which would enable magistrates to release them on bail. Again, from June 2013 to June 2014, young Indigenous people were 23 times more likely than their non-Indigenous mates to be in detention unsentenced, so on remand. How does the mandatory sentencing work? A 16-year-old with 1 prior conviction receives a 28-day prison sentence for stealing a bottle of water. A 17-year-old first-time offender receives a 14-day prison sentence for stealing orange juice and minties. A 15-year-old boy receives a 20-day mandatory sentencing for stealing pencils and stationery. He died whilst in custody. An Aboriginal woman and first-time offender who received a 14-day prison sentence for stealing a can of beer. You may recall Ms. DHU, a mother of 4, sentenced in Port Hedland Police Station in August of 2014 for unpaid fines, motor vehicle fines of $3,600, died in the lockup. Now, these are not unusual. I'm not making this up. This is a fact. This is how children are being detained in custody in this country. So, in New South Wales, the imprisonment rate for young Aboriginal teenagers in northwestern New South Wales, again for majority of motor vehicle offences, is between 10 and 15 times more than the non-Indigenous teenagers. 16% of Indigenous people who entered prison in 2013 were there only for fine default. An awful lot could be achieved by reinvesting the money spent on housing the prisoners and directing it to community programs. So clearly, mandatory sentencing is something that needs to be repealed. Fine default imprisonment is something that needs to be reviewed. And money needs to be challenged and spent on housing prisoners in community projects aimed at keeping them out of prison. This year, the Northern Territory Chief Minister has stated that his government intended to introduce legislation that would see a presumption against bail for juveniles accused of repeat property offences. I'm not going to stand here and pretend that these kids that are in custody are little angels. I'm not, I've represented them. But at the same time, most of this criminal activity arises out of poverty, arises out of boredom. Children should not be jailed for stealing bottles of water or minties. Now, that legislation that I just spoke of, where the bail laws will be changed to see a presumption against bail, I think Belinda's got some more information about that, but it's been propounded this year. That's a perfect example. If we had a Human Rights Act, before that legislation went before the Northern Territory Parliament, there would have to be checks and balances to consideration whether or not it complied with our Federal Human Rights Act. It wouldn't. Such a piece of legislation would probably be contrary to the International Convention on Civil and Political Rights, and also contrary to the Convention on the Rights of the Child. So why am I telling you all of this? Why am I rattling off all of these statistics? because the Indigenous incarceration rates, particularly those of children, is a national disgrace, and we need to do something about it. We as individuals and communities and as a nation have responsibility to keep our kids safe and to give them the best start in life. Our kids are not safe, and some of these kids are not getting the best start in life. And I feel responsible for that. I think we all should, and I want something done about it. Don't get me wrong, I don't stand here with all of the answers. I don't know. But I do know that we should talk about it. I do know we should have a conversation. Last night I attended the Sydney Town Hall where the Australian Human Rights Commission put on a Australian of the Year event. David Morrison, the 2016 Australian of the Year, was there. Elizabeth Broderick, the New South Wales Australian of the Year, was there. Julian McMahon, the lawyer that looked after Chan and Sukumaran, he was there. And a young fellow by the name of Nick Marchese, who's the Young Australian of the Year, who came up with the idea of helping the homeless by building a mobile laundry in his old van. It was a really interesting evening. One thing that all of the panellists discussed in one way or another was the power of storytelling, the power of conversation to inspire change. Nick Marchese, he spoke about hearing homeless people's stories when they sat waiting for their washing to get washed and dried, sitting on the orange chairs. Julian McMahon spoke about the impact on the Australian mindset of hearing stories about Andrew Chan and Sukumaran's families. You remember when Chan and Sukumaran were first convicted, and they were convicted of drug trafficking and sentenced to death. My memory is that there wasn't a lot of sympathy for them. They were considered criminals, and they were. But early on, there wasn't a lot of sympathy for their plight. Over time, that attitude in Australia and that opinion significantly changed. If you reflect back on the time just prior to their death, the attitude in this country was significantly different as to what it was when they were first convicted. And Julian McMahon puts that down to telling stories, to the Australian public being told the story about their families, and us seeing their families and seeing who they are and the impact on them. And last night, Elizabeth Broderick and David Morrison spoke of the power of hearing the story of a young woman in the Defence Forces and her treatment in those forces. So storytelling and conversation and communication is a very powerful way to inspire change. I want to inspire that change in all of you tonight. That's why I rattled off the stats. That's why I asked you to think about the kids when I was rattling off those statistics. Now, you all go and have a conversation. You go and tell somebody else the story, and you inspire change. Thank you.